Good morning, everyone. It's nice to see you this morning. I'm Rabbi Sue Shankman. I want to welcome you to Washington Hebrew and to our Amram Scholar Series and our fourth annual Leslie Maitland Lecture. And before we begin this morning's lecture conversation, I would like to share a little bit of background about both the Amram Scholar Series and the Leslie Maitland Lecture. And for those of you who know Leslie, she is not physically in the room, but she is joining us on live stream this morning as she is quite under the weather and was hoping to be able to be here. But we love you, Leslie. We miss you this morning. We look forward to seeing you when you are feeling better. The Amram Scholar Series offers a stimulating program of free lectures and conversations throughout the year in which world-renowned speakers, authors, scholars, political leaders, legal experts, policy analysts, theologians, and more share their perspectives on timely issues or their research into history. This program traces its beginnings to the fall of 1954 when Washington Hebrew moved into our Macomb Street home. That fall, participating in a nationwide celebration marking the 300th anniversary of Jewish settlement in the United States, the temple launched what would become a widely recognized Sunday morning program, now in its 70th year. The Amram Scholar Series, as we know it, was founded a decade later. Excuse me. I don't have Leslie's laryngitis, I just have allergies. It was founded a decade later in 1963 with an endowment from the estate of Adolph Amram and donations from temple families. In 1998, Rabbi Joseph Weinberg of blessed memory learned of Leslie Maitland's educational and professional background as both an alumna of the Harvard Divinity School and a former reporter for the New York Times, and enlisted her help in running the Amram Scholar Series. We are deeply grateful for the imprint she has made on this vital program. Leslie has poured her heart and soul into her dedicated mission of sustaining this exceptional lecture series and ensuring that its focus would remain nonfiction, with all speakers recognized as respected authorities on their varied subjects. She tirelessly organized, planned, arranged, coordinated, publicized, and moderated hundreds of topical lectures, speakers, and events. And she herself has been one of our Amram scholars, speaking on her own nonfiction book, Crossing the Borders of Time, a true story of war, exile, and love reclaimed. We are grateful to her ongoing commitment and are delighted to be able to present a lecture in her honor each year. And this is the specific lecture and conversation she has chosen, and we're so honored to be able to share it with Judge David Tatel. One of Leslie's major contributions was partnering with the Jewish Book Council to bring in engaging authors like this morning's speaker. This morning, we will have the pleasure of hearing Judge David Tatel in discussion with our WHC president, Jeff Weiss. Following their discussion, there will be an opportunity for Q&A with the audience, and at the conclusion of the program, Judge Tatel's book, Vision, will be available for signing. And now, I am delighted to welcome Judge David S. Tatel to Washington Hebrew. Judge David Tatel served on the United States Court of Appeals for the District of Columbia Circuit from 1994 to 2024, succeeding future Supreme Court Justice Ruth Bader Ginsburg. After graduating from the University of Michigan and the University of Chicago Law School, he served as the founding director of the Chicago Lawyers Committee for Civil Rights Under Law, and then director of the National Lawyers Committee. He headed the Office for Civil Rights of the U.S. Department of Health, Education, and Welfare during the Carter administration, and then founded and led the education practice at Hogan Lovells, where he is now senior counsel. Judge Tatel, along with Dr. David Baltimore, co-chaired the Committee on Science, Technology, and Law from 2016 to 2023. He also chaired the boards of the Spencer Foundation and the Carnegie Foundation for the Advancement of Teaching. Judge Tatel is a member of the American Philosophical Society and the American Academy of Arts and Sciences, and is the author of Vision, a memoir of blindness and justice. Judge Tatel and his wife, Edie, who we're so thrilled to welcome this morning as well, live in Virginia and Washington, D.C. They have 4 children, 8 grandchildren, and 1 great-grandchild, along with a furry friend, Vixen, who is here with us this morning. And we are so fortunate this morning to have our very own Washington Hebrew Congregation President, Jeff Weiss, as Judge Tatel's partner in discussion. And I believe this is now their 4th round of discussion, public discussions. They've had many private discussions as well. Most of those present are familiar with Jeff Weiss's involvement here at WHC in virtually every aspect of temple life. He is a 6th-generation descendant of our founder and first president, and in a wonderful piece of symmetry, Jeff is our 70th president. He's a graduate of Cornell University and the Wharton School of the University of Pennsylvania, and when not present at Washington Hebrew, and even when he is a leader in the energy business community. He and his wife, Christy, have raised their 4 children here at Washington Hebrew, celebrating B'nai Mitzvah, confirmation, and weddings with our WHC clergy. And they are also the proud grandparents to 3. And we are so grateful to Jeff for being part of this conversation. And we welcome Judge David S. Tatel to be with us this morning as our Amram speaker.
Thank you very much, Sue. Thank you so much, and welcome everybody. Thanks for joining this conversation. Thank you, Ira, for organizing and doing what you do for us every day. And Leslie, bless you and thank you. And I hope you can hear us and see us on the streaming today and feel better soon. David, thank you for sharing your time today and coming to Washington Hebrew, and welcome dear friend Edie and Vixen. So your book jacket reads that you championed justice your entire life. It feels appropriate to pause as we say hello, since we're in a synagogue, to tie you to our first president, George Washington, right? Yes. So George Washington quoted the Bible's Old Testament at Truro Synagogue about 45 years after apparently the first Jews came to America. And George Washington said at Truro, everyone shall sit in safety under his own vine and fig tree, and there shall be none to make him afraid. Washington continued, for happily the government of the United States gives to bigotry no sanction, to persecution no assistance, requires only that they live under its protection, should demean themselves as good citizens in giving it on all occasions their effectual support. David, you surely took that to heart. Thank you. As we get started, your book is so wide-ranging, and it is a memoir. It's much about Edie and Vixen, who only entered your life at the age of 77. You're the child of a physicist. You were hijacked by the civil rights movement to political science. While you're best known as a civil rights lawyer, we would usually start by discussing the relationship between law and science and talk about perhaps your chapter on the future of the planet. But given that's what we usually talk about, perhaps today we should start at a slightly different point. Given all that has happened since Trump's inauguration, might you write your chapters, The Planet and Democracy, differently if you were writing them today versus a year or two ago when you wrote them? Is there a threat to our planet and democracy from the president, not the courts? And if so, can the courts and how will they stand up? And what is the role of the courts in what's going on in our tricameral form of government?
Yeah. Well, that's a really profoundly important question, Jeff, and I'll answer it, but if I could just say 1 or 2 other things first. But by the way, the letter from George Washington that Jeff read from was hanging in my chambers in the courthouse for all 30 years I was there. It's a famous letter for lots of reasons. To me, the reason I had the letter there was that the phrase vine and fig tree, to me, symbolized the rule of law. And the rule of law, of course, is fundamental to our democracy. And that letter was a wonderful symbol of it for me. I also want, before I turn to this, Rabbi Shankman, I want to thank you for hosting me this morning and for being part of this wonderful lecture series. Mm-hmm. I got a lovely note from Leslie yesterday, and I'm sorry she's not here. I hope to meet her in person someday. And Jeff, this is our 4th discussion about the book. Jeff holds the world's record for discussing vision with me. And Jeff, there may be more in the future. So I want to answer your question, but since probably most people haven't yet read the book, I'd like to start just by reading a paragraph or two from the prologue to give you a sense of what this book is about. And then I promise to answer your question. I've lived a rich and varied life as a civil rights lawyer, as a federal judge, as a husband of 60 years, as a father of 4, as a grandfather of 8, and now as a great-grandfather. I've spent my professional career in the pursuit of justice, and I could have written a memoir entirely about that pursuit. But unlike most lawyers and judges, I've been blind for over half my life due to a rare inherited eye disease called retinitis pigmentosa. Throughout my 30 years on the nation's 2nd highest court, the United States Court of Appeals for the District of Columbia Circuit, I could neither read a word of the thousands of legal briefs submitted to my court, nor see the faces of the hundreds of lawyers who argued before me. A blind judge sounds like a cliche, I know, like the statue of Lady Justice wearing a blindfold and holding her scales. But it's no cliche to me. I can't see, but I can listen closely. I didn't need to see the lawyers to hear their arguments. And I absorbed all the written materials by having it read to me, or later by using digital audio devices. For decades, I fooled myself into thinking that my blindness was irrelevant to my work and my worth. Only now in my 80s, and in writing this memoir, have I finally come to accept my blindness as an essential part of who I am. This memoir is about my life in the law and my journey into blindness. It's also about the Supreme Court and my grave concerns about the state of our judiciary. Which brings me to Jeff's question. Near the end of the book, there are 2 chapters. One is called The Future of Our Planet. The other is called The Future of Our Democracy. The last chapter, by the way, is called The Dog That Changed My Life, about this magnificent creature here. And in those 2 chapters, I articulate my view, looking just at the Supreme Court's cases involving the big administrative agencies and environmental law, and the court's voting decisions. I explain why, in my view, I think our current Supreme Court has steadily abandoned fundamental principles of judicial restraint, and in the process has enhanced its power at the expense of the 2 elected branches of government. And why I think that's threatening to our democracy, primarily because it upsets the separation of powers that are so critical to protecting individual rights. Now, I finished the book before the end of the last term, that is, the one that ended in June 2024. And the court's decisions at the end of that term followed precisely that pattern, strengthening its own power at the expense of the other 2 branches of government. Now, Jeff's asked a really good question, which is, were I writing it today, how would it be different? The answer is, the titles of the chapters would be the same. But the threat to the separation of powers now comes from the White House. And the question in my mind, and I think the question in all of our minds, is to what extent will the other two branches of government check what many people see as the excesses of the Trump administration? To what extent will the separation of powers function as they have for 250 years? I don't think we can count on the Congress. The Congress has become not only dysfunctional, but has ceded its powers to the presidency, which is a tragedy because if you ask the framers of our Constitution which is the most important branch of our government, they would all say it's the Congress. It was the only elected branch of government. They gave it the power of the purse, the power to make war, the power to impeach. It was Congress that was the most powerful branch of government. And here we are in 2025 with a dysfunctional Congress that has not only failing to check the government, but has essentially turned its powers over to it. So that brings us to the courts. What will the courts do? Well, you've all read about the hundreds of court decisions in the district courts. But that's very early in the judicial process. And the ultimate question is, what will the Supreme Court do? Now we have one important indication already, which is reassuring. And you all read about the midnight order last week in the Abreu-Garcia case, where the court actually, for the first time, actually ordered the administration it didn't use the word facilitate, it ordered the administration not to deport anyone else until, quote, further order of this court. And, most important, the administration obeyed. It advised the Supreme Court that it would not deport any more alleged Venezuelan gang members until further order of the court. I think that's very important because we all wondered whether the court would ever order the administration, and we all wondered whether, if it did, whether the administration would behave. So here, early in the process, we have what I think is a promising sign. But it's only the first. And frankly, I'm not sure how much we can count on it in the future. First of all, it involved one of the more extreme actions by the administration. I mean, deporting someone without due process. But look at the polls. The American people don't like that. I think 80% in the weekend polls are against that. It's very important that the court did this, but it's not particularly controversial. And also, we can talk about this more if you like. My own view is that order was more about the court's own power than it was about due process. So, but nonetheless, it's an important development. So what about everything else? The government, the administration is defunding agencies, closing agencies. What will the courts do about that? Well, I think a majority of this court embraces the same theory of presidential power that President Trump does. And we'll have to see whether it's willing to restrain this at all. What will it do with respect to the administration's attack on non-government agencies like universities and law school and law firms? I am confident that the law firms that have sued will win their cases. I think the universities may, but I think a huge amount of damage will be done. And in terms of one more of the more extreme things this administration has attempted to do, I would be very surprised if the Supreme Court doesn't resist his efforts to eliminate birthright citizenship. So, long answer to this question is we just don't know yet. My own view is we can't count on the courts. The courts have limited power. The courts can declare what the law is. I hope they will, but in the end, this crisis we're facing has to be resolved through the democratic process.
Thank you. So What a great prologue to the next 45 minutes. For those who have read the book, you'll know that among the things that David does is he talks a lot about his career, his personal journey, his thoughts in these things, and then perhaps more than half the book is about cases, and I want to talk about some of the cases. But before we talk about cases, earlier in the book you talk about your personal journey, being the child of a physicist, hijacked by the civil rights movement to political science, and your relation, how you viewed your journey between law and science. And I think it's interesting, and I wish you would share your thoughts as to how you moved from one mountain to the other mountain.
Sure. So I grew up in Silver Spring, Maryland. My family, I grew up in the 50s in Silver Spring. My family attended what was then called MCJC. It's now Or Kodesh, where I was bar mitzvahed. My father was a scientist. He was a physicist at the Carnegie Institution of Washington. And he was interested first in the structure of the Earth, and then he became a pioneer in radio astronomy. When I was growing up, I was going to be a scientist. That was where I was headed. My father took me to his lab. He took me on scientific expeditions. When I went off to the University of Michigan in 1959, I went off as a major in science, but it was the 60s. And the turmoils of the 60s, the civil rights movement, and then the anti-war movement captured me. And while I loved science, I decided I wanted to be a lawyer. I was completely inspired. I was completely inspired by the lawyers who went south during the civil rights movement and the Southern judges who enforced the 14th and 15th Amendments. And so I ended up going to law school, and I was able, as I say in the book several times, I was in the right place at the right time, and I was able to involve myself for almost 3 decades as a civil rights lawyer, working on civil rights issues that I think are important. But I never put science behind me. I love science. I love biographies of scientists, and one of the things about the DC Circuit is we hear big cases from the agencies whose decisions are largely based on science, like EPA and FDA, and I love those cases because of all the science in them. And I spent, as you heard in Rabbi Shankman's introduction, I spent years chairing a committee at the National Academy of Sciences on science, technology, and law. And so science has always been part of my life. Let me read you this. It occurred to me after all these years on the DC Circuit that what I was doing as a judge really wasn't all that different than what scientists do. Let me just find this for you. This is just this is the last paragraph in chapter 17 called The Future of the Planet. The background of this, by the way, just so you'll understand one of the sentences, is when I was 15 years old, my dad took me on a month-and-a-half expedition to Peru, where we were measuring the thickness of the Earth crust. And I had my own seismology station, a little portable station. They dropped me off in the morning on the Altiplano, and I'd set up my equipment and do my measurements. And then, fortunately, they picked me up at the end of the day. And one of the things I had to do right when the measurements had to start was I had to chase away all the llamas that were there because, you know, the llamas would walk around and they'd upset the measurements. So that's the background you need for this. So, okay. So I write this after I described the big environmental cases I decided at the DC Circuit. Environmental cases always make me think about my father and our last expedition together, and not just for the obvious reason that environmental cases usually involve science. I was never lucky enough to draw a case about the tendency of llamas to disrupt seismographic readings. But I've always believed that the process my father and his colleagues undertook in Peru is the same one necessary to decide an environmental appeal. High in the Andes, we worked with seismological data and principles of physics. On the bench, it's the facts of the case and the relevant legal principles. In both contexts, the principles themselves never change, and good judges, like good scientists, must follow wherever these principles lead. So I don't know how many of you are lawyers or scientists, but I think we're all engaged in the same intellectual process.
Thank you. So you helped with an easy segue. So we're now going to talk for some time about some opinions and some of the work that you did because it's extraordinarily both relevant and fascinating and interesting. But you just started with the environment, so let's start there. So professionally, you touched on every major law from the Clean Air Act, which was passed under President Nixon, to the Clean Power Plan, NEPA, the EPA coal decision. You opined on whether the EPA, in fact, has authority and what authority executive branches have. May I ask you to go and talk about one particular example, which was your dissent in American Trucking versus United States EPA, a case about the EPA's power to set emission standards under the Clean Air Act. You rejected the majority's invocation of the non-delegation doctrine, arguing that the agency's actions were permissible. In a unanimous opinion written by Justice Antonin Scalia, the Supreme Court eventually reversed the majority's opinion, liberally adopting the reasoning of your dissent.
Mm-hmm. So that decision would come out differently today in this court. Here's what this is about. The reason we have clean air and clean water in this country is because of the Clean Air and Clean Water Acts. And the way they work is Congress passes a general law setting general standards, creates an expert agency, which then through regulation and action fleshes that out and based on the expertise it has, is able to adapt those standards to changing circumstances and constantly improve the quality of our air and water. That's why we have clean air and clean water in this country. Well, and there are hundreds of other administrative agencies that protect the safety of our food, the safety of our financial systems. They all work the same. Generic laws, federal agencies based on expertise enforcing those laws, producing the results Congress expected. For the past 2 decades, the independence of these federal agencies has been under attack. There are elements in the legal system who believe that these independent agencies interfere with Article 2 presidential power. And our court has been steadily chipping away at the independence of those agencies. Now, the case that Jeff mentioned predates all this. It was the first major attack on an independent agency, in that case EPA. And my court agreed with the challengers. It held that the Clean Air Act was likely unconstitutional because it violated a doctrine called the non-delegation doctrine, which the Supreme Court had used during the beginning to strike down much of the original legislation in the New Deal, but then immediately abandoned it. And the non-delegation doctrine has disappeared since then. The non-delegation doctrine basically says that Congress can't delegate its legislative authority to an administrative agency. It can't say, for example, to the agency, you must promote clean air. That's not enough. The non-delegation doctrine would require Congress to actually set the standards itself and not delegate that to an agency. Well, Congress isn't going to do that. It doesn't have the ability to do it, and it can't do it. So this was the first attack on the administrative agencies, and my court ruled that it violated the non-delegation doctrine. But the Supreme Court, 9-0, in an opinion by Justice Scalia, agreed with my dissent and reversed. That was the year 2000. That was 25 years ago. Since then, we've had this court steadily limit the ability of federal agencies to function. They've adopted something you've probably read about, the major questions doctrine, which limits the ability of agencies to interpret the law. At the end of last term, they even eliminated the variability of agencies to interpret the law by overruling something called the Chevron doctrine. And they now have, the Supreme Court now has back on its docket the non-delegation doctrine. And we don't know whether the court will adopt that or not. There are 3 or 4 justices who, in concurrences and dissents, have embraced the non-delegation doctrine. If it does, it will have a fundamentally, a dramatic effect on the effect. The agencies are already greatly limited in what they can do. This could effectively eviscerate independent agency power if that happens.
Let's go another layer into that, since you used the much-loved word Chevron, and talk about government and how government and how the balance of power works. So, didn't Chevron free agencies to do what Congress intends, while allowing the courts to rein in when constitutional parameters are overstepped?
Yeah, exactly.
Right. So the court overruled Chevron, the Administrative Protections Act, and doesn't that require Congress to pass something they don't usually do?
Yeah.
Extremely detailed laws, since the basic ones, as you just pointed out, don't include the very detailed rules to implement them. And oddly, as a result of this, what impact does this have on how the Trump administration may be acting now that it can't rely on Chevron either?
Well, it's interesting, being in Washington, I usually don't have to explain to audiences what Chevron is. There's been so much attention to it. Yeah, but Jeff is right. Remember I said at the beginning the court has steadily increased its own power at the expense of the elected branches of government? Well, this is a perfect example. In a case called Loper-Bright last June, the Supreme Court overruled Chevron. What that did was it dramatically expanded the power of the courts over the executive branch, because judges no longer have to defer to agency interpretations of statutes. Judges now make the decision. Judges are going to have to interpret these statutes themselves without any deference to agencies. So it's really shifted a huge amount of power from the agencies to the courts. It also took a huge amount of power away from Congress. Congress could have overruled Chevron if it wanted to, but it didn't. Congress has known that Chevron has been part of the law for 40 years. It didn't overrule it. Normally in our democracy, the way you make changes like that is Congress holds hearings, listens to witnesses, and enacts legislation. But no, the court did it itself. In fact, there's a really interesting sentence in the Loper-Bright decision that I didn't notice until I reread it a couple weeks ago. It says, yes, Congress could accomplish this, but we don't see any reason to wait for that. We don't see any reason to wait for the democratic process to work. That's what the Supreme Court was saying. Now, as a result of this, what will happen is you will find more and more court decisions ruling that Congress has not authorized an agency to take a particular action. That is, to issue a particular kind of regulation or enforce a particular standard. Those are going to get routine now. The only way to fix that is for Congress to act. That is, for Congress to set the standards. And as I said at the beginning, both because of Congress doesn't have the expertise to do this. Congress doesn't have the patience to do it. And more important, because of the way we finance our elections, Congress is accountable not to the people anymore, but to the people who pay them. And also, this Congress is not about to enact the kind of specific legislation that would limit the president. What I've never understood, this big question I have, Jeff, is whether the people who were so interested in having Chevron overruled now regret what they did.
Right.
Yeah, I mean, it's like the dog that caught the bus. You know, now suddenly, now that they get to staff the administrative agencies, they may regret the loss of Chevron.
Right.
Big time.
Well, that'll be so interesting to see. You wrote another opinion that is a great example. We're going to talk about tax.
About what?
Taxes.
Taxes?
Taxes. We're going to talk about taxes for a minute. So you wrote a majority opinion in Trump versus Mazars.
Oh, yeah.
Right? That's
Right.
about taxes.
Yeah.
But
Not your taxes or my taxes, his taxes.
right. But from many points of view, it's also an extension
Yeah.
of what we've just been talking about, which is the seesaw back and forth as to how decisions influence who controls what and who can do what. So your majority opinion in Trump versus Mazars, Mazars is an accounting firm that Donald Trump has used for a long time, finding that you wrote that the U.S. House had authority to compel Mazars, the accounting firm, to produce tax documents. The House of Representatives was trying to compel, and you said they could. The Supreme Court vacated your ruling and remanded 7-2, and the opinion of the Supreme Court was written by Chief Justice Roberts.
Right.
Tell us your thoughts about that.
So this was, Mazars was, as Jeff said, a lawsuit where the Congress was seeking to enforce a subpoena directed to President Trump. This is the first Trump administration, to produce a whole set of financial information, including tax returns. I wrote the opinion for my court enforcing the subpoena. It went to the Supreme Court, and the Supreme Court reversed. But it was an interesting reversal because the Supreme Court said they were reversing because the D.C. Circuit, that's my court, had failed to take account of certain things, like we hadn't sufficiently examined whether Congress was engaged in a legitimate legislative activity. We hadn't looked carefully to make sure the subpoena wasn't overbroad, things like that. Well, the fact is we had done all of those. And the Supreme Court's opinion really looked a lot like my opinion. My own view is that what was happening here was, first of all, what was happening here was that the court, what the court was doing was issuing an opinion that made it clear that although they thought we hadn't done it sufficiently, on remand, the subpoena might be enforceable. And I thought, my theory was they were sending a signal to the administration that, you know, this subpoena might end up actually being enforced. I don't know whether that's true or not, but if it is, you know, I say in the book it's the best reversal I ever had because the opinion's actually really good, and I think does a nice job of articulating the relative responsibilities of Congress and the president. And in the end, it was resolved. Came back to the lower courts, and the lower courts issued a slightly modified decision, and the president obeyed, and the issue was over. It was a perfect example of the courts and the executive branch avoiding a clash, which is dangerous for our country. It's dangerous to have a situation where, you know, the courts order the administration to do something and it doesn't do it. That's very threatening to the rule of law, and that was a good example of how courts can avoid it.
Thank you. So earlier in this conversation, you advised about the importance of voting.
Yeah.
That in democracy, voting is fundamental. Let's talk about voting for a minute. You wrote the majority opinion in Shelby,
Right.
upholding the constitutionality of the Voting Rights Act. The Supreme Court reversed you 5-4. You've been involved in many major cases involving the 15th and the First Amendments. Whether you focus on Shelby or otherwise, would you care to discuss that?
Yeah. So again, this is like Chevron. I think everybody knows what the voting rights is in Shelby. Voting Rights Act, 1965, probably the most effective civil rights law ever passed. It required southern states with a history of discrimination to submit any voting change to the Justice Department to prove it was not discriminatory before they could implement it. Had a dramatic change in the South. It had been challenged 4 consecutive times in the Supreme Court. 4 consecutive times the Supreme Court found it constitutional under the 15th Amendment. The 15th Amendment, which was added to the Constitution after the Civil War, dramatically changed the relationship between the federal government and the states. Up until then, the federal government had virtually no responsibility for elections. It was all states. But after the 15th Amendment gave Congress responsibility to prohibit racial discrimination in voting. Took the power away from the states. It's one of the most dramatic changes in the structure of our government in history. And based on that, the Supreme Court 4 times said the Voting Rights Act was constitutional. Well, flash forward to 2006, Congress extends the law again, and this time the Supreme Court, on a 5-4 vote, declares it unconstitutional. Whereas if you look at the previous opinions, or my opinion sustaining it, what you see is discussions of the evils of racial discrimination in voting and the power of the federal government under the 15th Amendment to eliminate it. If you read the Supreme Court's opinion in Shelby County, the only thing you see is the extent to which the Voting Rights Act interferes into state autonomy. That's what the court was concerned about, that it interfered with state independence, which of course was exactly what the 15th Amendment had ended. So here, this is a perfect example of the problem with this court, is that, and it was 5-4, the Republicans in the majority, the Democrats in dissent. In the previous 4 cases where the court had upheld it, 29 justices from both parties had agreed it was constitutional. Now, on a 5-4 vote, it's unconstitutional. And in declaring unconstitutional, you have the court disregarding the plain terms of the Constitution, congressional findings about voting discrimination, and basically turning the amendment upside down from a concern about eliminating evils of discrimination in voting based on race to protecting state autonomy. That is a classic example of the court reaching a result through decidedly non-judicial means, and the consequences of that are enormous. Eliminating Section 5 produced a wave of voter suppression legislation throughout the South. In the Shelby County opinion, the court reassured us, said, don't worry, there's still Section 2 of the Voting Rights Act, which is the standard enforcement mechanism. That will protect everybody. But then 3 years after that, in a case from Arizona, they eviscerated that. So the Voting Rights Act has been gravely weakened by this court. Now, even if you think whether the Voting Rights Act was too intrusive into state autonomy, that's a debatable question. I happen to think it was justified. There are people whose judgment I trust who think it was too intrusive. The point I've made in this book is, even if you think the Voting Rights Act was too intrusive, or even if you think that Chevron's a good idea, that overruling Chevron's a good idea, you should be as worried as I am by the way in which the court is reaching those results. Regardless of what we think about the environment, regardless of what we think about voting rights, we all have an interest in making sure that our courts, which are unelected, are following the rules of judging and not intruding into the actions of the political branches of government. And so, regardless of your views about the outcome of the case, we should all be worried about how the court is getting there. And my book is about judging. It's about judging more than it is about the outcome of cases. And if there's a basic theme to the book, it's my warning that, as I said, regardless of what you think about the outcome of these cases, all Americans should be worried about the way the court is getting there.
Well, maybe that is a good segue to ask about something that's current but involves First Amendment cases that you were deeply involved in. So in one, you wrote the case involving Judith Miller and the rights of reporters to refuse to disclose their sources to a grand jury. And the case, and then there was the case upholding an order to restore, imagine this, a White House press pass after a reporter got into an argument with one of President Trump's then supporters.
Yeah, so the Judith Miller case, you all know, everybody knows about Judith Miller. I wrote the question again was, you know, she received a subpoena from a grand jury and was ordered to reveal her sources. The reason that, I won't go into the details of the case, but the question was, does a reporter have a First Amendment right not to disclose her sources? That was the question in the case. I ruled, based on a very clear, binding Supreme Court decision decided 25 years earlier, that the answer was no. Court had said there was no First Amendment right for a reporter. I thought there was a common law right. Common law is the laws articulated by the courts. And I articulated what I thought that would be. But I agreed with my colleagues that there was no First Amendment right. The reason that's in the book, that story's in the book, it's not just because it's a really interesting case, but because the New York Times editorials criticizing our decision said we had disregarded the First Amendment. And I put this in there because, as I say, you know, editorial writers, just like judges, are entitled to their own opinions, but not to their own facts. And when the New York Times wrote its editorials criticizing us for ignoring the First Amendment right of a reporter not to reveal sources, they were misleading their readers on an issue of huge public importance. And although their coverage of the case, their factual coverage of the case, was quite good, I thought their editorials were irresponsible because here they were involving the paper in a highly contested issue, and people who read those editorials would have actually thought that the courts were ignoring the First Amendment, which was just not true.
So I could go on for a very long time with you, and I'm going to ask you one more question, but before I invite others to ask questions, because I know there are folks here who would like the opportunity to do that, and then we can close up after that in a little bit. Another topical case that I think is of interest is that you got involved in Guantanamo Bay.
Yeah.
Right, and you not only got involved in Gitmo and Guantanamo Bay, but in particular about the balance between civil rights and law. Yeah. You wrote the decision to vacate the case against KSM, Khalid Sheikh Mohammed, who was the mastermind of 9/11. Tell us about how you thought about that and how that came down.
Well, you know, suddenly Guantanamo's relevant today because what's happening with, if you think about what this administration is doing with alleged gang members from this Venezuelan gang, is they're deporting them to another country where they'll be beyond the reach of our Constitution, right? That's what's happening. It's exactly what the Bush administration tried to do with Guantanamo. The Bush administration decided to confine, when they brought the people, the detainees back from the black sites in Poland and Hungary, they needed to find a place for them, and they decided Guantanamo was it because it was beyond the jurisdiction of the federal courts. That's exactly what the Trump administration now is saying about El Salvador. But then the Supreme Court, 5-4, I have to say, ruled in a case called Boumediene that that was wrong, that the U.S. had de facto sovereignty over Guantanamo, and that the Constitution, or at least the habeas corpus provisions of the Constitution applied. And as a result of that, my court I spent 20 years deciding habeas cases from Guantanamo, which allowed us, through which the courts applied fundamental legal principles to the detainees in Guantanamo. The one Jeff mentioned is the basic principle that anybody charged with a crime should be judged by a non-biased judge. And in the particular case he's mentioning, involving KSM, the judge had been going around the country giving speeches saying that KSM was the mastermind of 9/11. This is the judge who was supposed to judge him, right? Because they detained him in a place subject to the Constitution, we were able to reverse that. Question now is what's going to happen here? Is the Supreme Court going to think about El Salvador? Obviously, El Salvador is an independent country, but they're confining these deportees pursuant, apparently, to a financial contract with the United States government. So how is the court going to look at this? So history repeats itself, right?
Which is,
Yeah.
in essence, the theme of vision. History repeats itself. Before we close and have a few minutes, let's ask if others have questions.
So I know there are a few questions here, but
Yeah.
before I bring the microphone around to call on people, it seems appropriate that for the Leslie Maitland lecture, I'm not sure if you can see me, Leslie. Leslie sent me a question
Oh, good.
as she is watching and listening, and she says, Judge says it was important that the court ordered the White House to facilitate Garcia's return from El Salvador, but White House has not obeyed. She asks what we can do when the executive branch refuses to obey court orders. Checks and balances are lost. It turns out there's a loophole in our system. The Marshal Service is supposed to enforce court orders but take direction from the AG. So when the president doesn't obey the court has no recourse and the decision is toothless with a question mark? This is from Leslie.
Yeah. I mean, Leslie has put her finger on, as I said at the beginning, on a question we've all wondered about. What happens when the court orders the government to do something and it refuses? You know, in history, historically, this hasn't happened. When President Truman seized the steel mills during the Korean War, Supreme Court ruled against him, and he obeyed. When the Supreme Court unanimously ordered Richard Nixon to turn over the Watergate tapes, he obeyed and resigned. So what's going to happen now? Well, I actually thought, so the first order the court issued in the Abreu Garcia case, it said they had to facilitate his return. And I think what the court was doing there, and they said that unanimously, by the way, I think the court was trying to send a signal to the administration, which is, hey, we're serious about this. You need to get this guy back. But when a week later, when they hadn't done it, and a different case came to them where 2 buses were on their way to the airport with another 25 deportees, I think then the court did issue an order. It said those people cannot be deported until further order of this court, and the administration obeyed. So at least there, we avoided a constitutional confrontation. That doesn't mean we're out of the woods. There's many areas, I think, where we're going to face situations like that, but at least at the moment, it hasn't happened.
Judge, you've spoken about the balance of powers between the legislature and the executive and the judiciary. One of the issues I think we will see in the coming months is President Trump's attempt to fire people from different government agencies,
Right.
and whether the court is going to overrule Humphrey's executor. I'll keep my question short and let you explain and give your thoughts on where we're headed there.
Well, you know, predicting the court is difficult. You know what Yogi Berra said, making predictions is very difficult, especially predictions about the future. And I have predicted this court inaccurately so many times. I'm not going to start today, but here's what I think. There's two basic issues. You mentioned one of them, Humphrey's executor. That's the 1930s decision sustaining the constitutionality of the FTC. The statute says that members of the commission can only be removed for cause. The conservative legal movement, the same movement that brought us Dobbs overruling Roe, that brought us Loper-Bright overruling Chevron, that brought us many of these cases, wants Humphrey's executor overruled. They believe the president under Article 2 should have absolute authority over everything in the executive branch, and that any limitations on his ability to hire or fire are unconstitutional. And this issue is before the court right now in a case involving the NLRB and the Merit Systems Protection Board. I think they'll overrule Humphrey's executor, but maybe they won't. One of the reasons they might not is this is exactly the way the Fed is structured. And I think even though they may want to limit the independence of federal agencies generally, I think even they might be afraid of subjecting the Fed to political pressures. So we just don't know about that. We'll have to wait. My guess is that case will be argued and decided before June. Then at the other level is, what about firing just employees, workers? Well, the federal government, the president has a huge amount of authority over this. A lot of the people who have been fired are probationary, and my guess is the court's going to sustain that. He has a lot of authority over the upper levels of the senior civil service. He wants to convert a lot of civil service to Schedule, what do they call it, F, which will give him presidential power. Question in my mind is, what will they do with the core civil service? The hundreds of thousands of civil service employees who work under civil service protections. Will the court declare that unconstitutional or not? I hope not. But our problem is, as I think I said, that a majority of this court has the same expansive use of presidential power that the administration does. So we'll have to see.
But I can ask a different one. I was going to ask Humphrey's executive question, but you beat me to it. So I'll ask a different one. This is a lawyer, but not in the weeds. So everybody forgive me.
I'm sorry, what?
I'm trying to be not in the weeds of the law.
Yeah.
Put it right there?
That's much better.
Not in the weeds.
Not in the weeds.
So I'm a little, the unitary executive theory, which is what you are referring to, is the theory of the plenary power of the president. And my question is, have the courts used, or do you think they should use, the clause about the oath to make sure that the laws are faithfully executed, which presumably means the laws passed by Congress? Does that act as a check on the power of the president if he doesn't faithfully execute the laws passed by Congress, or am I just reaching a bridge way too far?
No. That's a good originalist question. I mean, there are two competing phrases in Article 2. One is the one you mentioned, president shall take care that the laws are faithfully executed. And the other is the executive power shall be vested in a president. Those are the two clauses. And it's the vesting clause that the opponents of Humphrey's executive rely on. Now, in the Humphrey's executive case, I mean, the president, yeah, he is, when he fired the NLRB, the head of NLRB, he was violating the federal law. No question about it, right? But his argument is it's unconstitutional. Is he faithfully executing the laws? I'm not sure how you think about that there. But faithful execution is is certainly a critical part of how one thinks about this. But I honestly, in the end, don't know quite how this is going to come out. I do think once we're finished, the president's going to have a lot more flexibility than he does now. By the way, where the faithful execution clause is really important is in all of these challenges to his firing huge numbers of employees and closing agencies. I mean, and in fact, I don't know whether you saw it, but last week, a district court entered a preliminary injunction in the Voice of America case, basically saying that this violated his duty to take care that the laws are faithfully executed. Congress had created the Voice of America and funded it. And he was closing it and not spending the money. And the court said that's a separation of powers problem.
Yeah. Your Honor, thank you for your insights. Just a question on the ability of the judiciary to bear this weight. You know, the hundreds of cases that are being filed in response to Trump.
Yeah.
You know, rulemaking in response to Loper Bright, vacancies that still exist. Is this too much for the judiciary? And what happens if we get to this impasse, like Judge Boasberg's orders being ignored and not getting documents that he requests or needs in cases? Where's the strain going to lead?
Yeah. Well, there's sort of two questions lurking in your question. One is, you know, can the courts handle all of these cases? And the answer is yes. You know, our district courts and courts of appeals, they can handle this. I faced the same thing at the beginning of the first Trump administration. We had dozens, hundreds of cases, which we were able to handle. So I'm not worried about that. You know, the more difficult question is the one you ask about Boasberg. And we're just going to have to see here. We don't know. The D.C. Circuit already, Boasberg issued a basically discovery order to try to get to the bottom of whether the administration violated his orders regarding those 3 airplanes. That's what he's done. He's issued a discovery order. And it went to the D.C. Circuit, and the D.C. Circuit stayed it until it can hear it. And the D.C. Circuit's view about that won't be final. It'll obviously end up in the Supreme Court. So we'll have to see. You know, but the really critical question here is, let's assume that the courts allow the judge to go forward, and let's assume he finds the Attorney General, let's assume he finds they violated his orders and did it consciously. And so what does he do? Normally, you can hold a defendant who violates a court order in contempt. You can do it in civil contempt or criminal contempt. And judges have done both. The problem with respect to contempt in a case involving the government is contempt orders are enforced by the Marshal Service, and the Marshals work for the Attorney General. Now, you know, Judge Boasberg said in his order, he acknowledged that, and he said if it came to the point where he thought there was a violation of the order, he would appoint a prosecutor, an independent counsel, which he can do under the federal rules. But the constitutionality of that has never been tested. And I wouldn't be a bit surprised to see that court declare that unconstitutional on the theory that the prosecutorial function is an executive function, not a judicial function. And you can't have the courts wearing both hats. And I would actually probably agree with that result. So what happens in the end? It all goes back to a very famous case, Marbury versus Madison, which says that the court shall declare what the law is. And that's the end of their authority. Under our separation system of government, for 250 years, we've assumed that if the courts declare what the law is, as they did in the Steele seizure case and in the Nixon tapes case and in the Little Rock school desegregation case, I go on. The court declares what the law is, the president obeys. That's the way it's been. If the president doesn't obey, I suspect if we ask if Alexander Hamilton and John Ness and the rest of them were here, and we said to them, "What would you do? What would happen in a situation like that?" I think they'd probably say, "Well, that's why we put the impeachment clause in the Constitution. That's a high crime and misdemeanor." But of course, we have a dysfunctional Congress, right? This Congress isn't going to do anything like that.
So we have one more question, and then I'll ask you a final question to wrap up.
Okay, you actually moved toward my question, which is shockingly, at least to me, there are advisors to the president and some of his supporters who think that the Supreme Court doesn't have the right to decide what's constitutional, that nowhere does it appear in the Constitution, which effectively is overruling Marbury versus Madison, almost 200 and whatever something years of law. What do you think about that? And do you think they could get anywhere with that? Would the Supreme Court put itself out of business?
I'm worried about a lot of things. I'm not worried about the vitality of Marbury versus Madison. Don't worry about that. I can give you a long list of things to really worry about. That isn't one of them. However, it's if you were teaching high school common law, that'd be a great question to discuss with your kids, right? That'd be really fun. But don't worry about it. It's not going to happen.
So let's spend the last few minutes talking a bit personally, right? So, you in the book talk about all the tricks you used to deny your visual impairment. You hid it. You surreptitiously brushed people's elbows to find the way where you were going. You famously had a lot of business where you had to fly to New York City, and you managed to stay in the same hotel and have the exact same path because you physically knew how to do that. So many things. And you've also talked about learning about that and about yourself in writing the memoir. And you've discussed elsewhere the emails you received and the impact on, and in fact, as to how you actually wrote this as a partnership together, and the impact of Vixen on your life and marriage. So if you could talk some of the personal as we wrap up, I think that would be very helpful.
Yeah, sure. Just the background is, when I was 15, I was diagnosed with retinitis pigmentosa. I had trouble seeing at night. That was the symptom. And I was 15 years old, and when I came home, I didn't say to my friends, "Hey, I have this disease." I didn't tell anybody about it. Here, let me just read you a sentence or two here. How much time do we have? I don't want to.
3 or 4 minutes.
All right, I'll just skip the reading. I hope you'll buy the book and read it. And I developed lots of techniques for hiding my declining sight. For example, when I go to the movies with my friends, when the lights went down, I couldn't see. And instead of asking one of them to get the popcorn, I would go get it. I'd count the seats down and then the rows back up, and then I'd do it backwards to get back to my seat. And I had lots of tricks like that. First of all, to hide my blindness, which I did for maybe 20 years. Through law school, through initial practicing law, I hid it as much as I could. And even by the time in my mid-30s, when my sight declined dramatically, and I had no choice but to start using readers and get help from people, even then and when I got a cane, I used a cane for many years, I never talked about it. It wasn't me. It wasn't when I went on the DC circuit, I didn't want to be known as a blind judge. I wanted to be known as a judge who happened to be blind. And so the story I tell in the book, and sort of the story of my life, is first covering it up and then treating it as unimportant and not talking about it. So why am I here talking to a bunch of people I don't know about a subject I refuse to talk about? Well, there's really 2 reasons. One is this book. This is a book that Edie, my wife, and I largely wrote together. She's a great writer. And this is a story about us. So it's not just that Edie's a good writer, but this is a memoir of us, of our lives together. I'm the one who's blind, but blindness obviously affects Edie and our marriage and our children. And what the book did for us, as we worked on it together, was force us to think very deeply about these questions. You know, why did I behave the way I did all that time? What effect did my blindness have on Edie? How did it affect the children? We gave our kids, we sent them a 10-question survey, which they answered. When you read the book, when you see quotes from the children, it's from this survey that they gave them. And so we learned a huge amount about ourselves and our family in the process. And I became more comfortable with talking about blindness. You know, I had no idea when I started this process, Jeff, I thought I was just going to tell my story. I had no idea that writing a memoir could be such a profound experience. So I say in the book at one point that writing the book is the coda to my experience, and it is. It is very much a result of writing it that I'm now so comfortable talking about it. The second reason is this wonderful guide dog here. You know, when I had a cane, you know, people didn't come up to me and say, hey, that's a really cool cane, how does it work, right? But now that I have a guide dog, everybody wants to talk about the dog. You can't have a guide dog and be uncomfortable talking about blindness. So, and I love to talk about the dog. And so Vixen has also made me much more comfortable about blindness. I'll say one more thing, Jeff, which is just as writing the book has been an extraordinarily important event process for Edie and me, so is the aftermath of the book. And this was completely unanticipated. This book came out June 11th, 2024. Since then, I've had dozens, maybe hundreds of letters and emails from people who say something to the effect of, I read Vision and it tells my story too. And it turns out that these are not just from people who are losing their sight, people who are losing their hearing, people who have mental issues, people who have diseases, whatever, people who have hidden disabilities, hidden problems. They all reacted the way I did. They covered it up. I even got a letter from a law student a month ago who said she still counts seats in the theater. She still does exactly what I did. This was a really profound thing for Edie and me to learn, because when I was a kid and a young man and hiding it, I thought it was just me. You know, I didn't have anybody to talk to about it. And now I realize this is just human, that this is what people do when they're struggling with an issue like that. You don't talk about it. You hide it as long as you can. And one of the things I now hope for this book, and I hadn't written it for this purpose, but now that I understand that I was not alone, you know, I hope sighted and unsighted, or people without disabilities, although I don't think there's such a thing as people without disabilities. Everybody has something. I hope that people who are struggling the way I did will realize that it's better to be honest about these things, to talk about it. And it's better for society because, you know, although we've made a lot of progress in terms of bringing people with disabilities into the mainstream, we still have a long, long way to go. And that progress will be enhanced if we know more about people who need accessibility. So, so it's been to just, you know, as I said, I had no idea what I was getting into when I started this, but writing the memoir and the consequences of it have been such a profound impact on me and Edie. It's been really, as you might say, eye-opening.
What a perfect thing to say, and as we conclude, and just as Washington Hebrew to say thank you.
You're welcome.
We began this morning speaking about George Washington's comments at Touro Synagogue about the vine and the fig tree.
Yeah.
We've discussed law, life, values, leadership, and impact. Indeed, you championed not just justice, but vision throughout your life.
Thank you.
Thank you very much
Thanks,
for
Jeff.
sharing with us.
Thank you.
And just a reminder to everyone, Mother's Day is coming up, Father's Day is coming up. This will make a great gift. We invite you to join us out in the atrium where Judge Tatel will be signing books. We encourage you to pick up a copy for yourself or someone you love. And so grateful to both Judge Tatel and also to Edie and to Vixen for being with us. And a thank you to Jeff Weiss as well.